So hello everyone, welcome back again to my channel, and hello to all my subscribers. So we just got a great news today with the USCIS regarding our application. So as of now, the I-944 form is not available now in USCIS. So this is with regards with the inadmissibility on public charge grounds. Sorry about getting all tongue twister right there. So I'm here to just explain it, but much that is said here on the website is already self-explanatory, so I'll go ahead and read this for you. So on November 2, 2020, the U.S. District Court for the Northern District of Illinois vacated the admissibility on public charge grounds final rule as amended by inadmissibility on public charge grounds. And that decision was stayed by the U.S. Court of Appeals for the 7th Circuit. On March 9, 2021, the 7th Circuit lifted its stay, and the U.S. District Court for the Northern District of Illinois order vacating the public charge final rule went into effect. So we immediately stopped applying the public charge final rule to all pending applications and petitions that would have been subject to the rule. USCIS continues to apply the public charge inadmissibility statute, including consideration of the statutory minimum factors in the totality of the circumstances in accordance with the 99 interim field guidance, which was in place before the public charge final rule was implemented on February 24, 2020, to the adjudication of any application for adjustment of status. In addition, USCIS will no longer apply this separate but related public benefits condition to applications or petitions for extension of non-immigrant stay and change of non-immigrant status. On or after March 9, 2021, applicants and petitioners should not provide information required solely by the public charge final rule. That means that applicants for adjustment of status should not provide the Form I-944 Declaration of Self-Sufficiency or any evidence or documentation required on that form with their Form I-485. So, as said here, all the applications on or after March 9, 2021 does not need to submit the Form I-94 anymore. So it's totally gone. All right. Also, applicants and petitioners for extension of non-immigrant stay and change of non-immigrant status should not provide information related to the receipt of public benefits on Form I-129, Form I-129CW, Form I-539, and Form I-5398. So this is like for the Fiance visa. So for all the K-1 visas that they are processing right now, they don't have to pass the Form I-944 or any evidences regarding the public charge rule. Next, if an applicant or petitioner has already provided such information and USCIS adjudicates the application or petition on or after March 9, 2021, we will not consider any information provided that relates solely to the public charge final rule, including, for example, information provided on the Form I-944, evidence or documentation submitted with Form I-944, and information on the receipt of public benefits on Form I-129 and all of the other visas. And yes, with regards with our application, I've already submitted the I-944 or Declaration of Self-Sufficiency together with my I-485 application or my adjustment of status. So I think they will just not consider it anymore as a vital information in our application. So all of you guys who already submitted it on or after March 9, 2021, you're just going to be good to go with or without the I-944. So we're all good to go with our applications right now. Yep, and that also includes the people who received a request for evidence or notice of intent to deny requesting information that is solely required by the public charge final rule, including but not limited to Form I-944, and your response is due on or after March 9, 2021, you do not need to provide the information, okay, if it is only solely required about the public charge final rule. However, you also need to respond to the aspects of the RFE or notice of intent to deny that otherwise pertain to the eligibility for the immigration benefit you are seeking. So this is self-explanatory. If they require a response regarding this, just disregard it. Okay, and if in case that you receive a notice of intent to deny, I highly suggest you resend your application again. Because of course they will reconsider it now that the public charge final rule is already gone. I think you'll have a higher chance now, so I highly recommend you resubmit your application. And again, it says here we will issue additional guidance regarding the use of affected forms. Until then, USCIS will not reject any Form I-485 based on the inclusion or exclusion of Form I-944. We will also not reject Form I-129, 1I-29CW, and all of the other forms based on whether the public benefits question have been completed or left blank. So generally they will just disregard anything that is, about the form I-944. So they won't solely, rely on that form if they're gonna reject you or not. Okay, so we're all good to go. This is a good news for us because that is just like, a relief. Well, in my opinion, I think I-944 or Declaration of Self-Sufficiency is irrelevant on our case as long as you are in the poverty guidelines. If you're into it, then you're good to go. So yeah, so if you do have any questions, you can just comment down below and I will be providing the link to USCIS, or you can just check it on the website. So thank you guys for watching, and I hope you'll all have a great day and stay tuned for my next update. Have a good one.